Good morning, ma'am. Are you Christina Rodriguez? And this is 17-27256. Ms. Rodriguez is on probation for injury to a child, elderly, or disabled individual. There's a motion to revoke that's been filed. There was a request for a competency evaluation. I'm going to take judicial notice of the court's file. Ms. Rodriguez was evaluated by Dr. Rapon. I've got that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. And so is there any other evidence with regard to competency?
No, Your Honor. No, Your Honor.
Then at this time, based on that report, I will find Ms. Rodriguez competent. And where are y'all on the case? And what's the announcement?
If we could give probably a couple more, it's more than likely this may need to lead up to a hearing. From our conversations with Ms. Rodriguez, she doesn't believe she's committed the alleged allegations.
Okay.
So
you want just a couple of weeks, and then that way, if we're going to have a hearing, we need to go through the motion.
Yes.
It's still going to get pushed back. So let's just do maybe a 2-week
That's
reset.
fine.
Okay. Well, reset at 2 weeks. Ms. Rodriguez, Ms. Holmes will be out there to visit with you about your options. And then with the next court date, we'll get pleas of true or not true and then see where we go from there.
Yes, ma'am.
Okay. You can go back with the bailiff.
Brittany, I won't be here that week, but it's okay. I'll let somebody else take those.
Good morning, sir. Are you Kevin Thomas?
Yes,
And this is 26 DCCR 0798. Mr. Thomas is charged with assault on a security officer. Mr. Wilkerson, what is the announcement?
Your Honor, Mr. Thomas would like to proceed to trial on his case based on the underlying facts of the incident. I anticipate filing a notice of affirmative defense. And so I will get that filed. I've also got a HIPAA release that Mr. Thomas has signed. I do need to, some time for those subpoenas to come back. So
there was already a plea bargain rejection. It looks like that was signed, June 16th, with a rejection of 15 years. Any change in that offer?
Yes, Judge, I have inherited this case from Mr. Coleman. I put a note to myself, see if Mr. Wilkerson and I speak in lieu of some notes that Mr. Coleman left before he switched courts. Before he maybe jumps through all of those hoops with those subpoenas, I understand where he's going. I think I'm probably going the same direction. Maybe one more setting before we were to place it on the trial docket. Let him get those in the works.
Sure, let's do
might be
that.
productive.
Get with Ms. Malfino now that she's on that case, see if there's any new negotiations. Go over that with Mr. Thomas, and we'll, if it needs to be on a trial, we'll put it on at the next court date.
yeah, Your Honor.
Okay, all right, you go back with the bailiff.
that's the thing.
Then you got Javian Blunt.
Yes, Your Honor.
Davian Blunt.
Good morning. Are you Howard Dwayne Walker Jr.?
This month.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Walker, in clause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
yes,
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. DeLage?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was gonna email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as
Yes.
possible, and because the case has to get closed out,
Right.
then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to take these?
But that's what's alleged is that and how.
Thank you.
Thank you,
And
Nancy.
may I excused?
Yes, thank you. Good morning, sir. You're Michael Powell or Micah Powell.
Yes, good morning.
And this is 25 DCCR 1522. Mr. Powell's charged with burglary of a habitation. And what is the announcement?
Yes, Your Honor, we received an offer this morning. I've relayed it to the client. I've also given that information to Mr. Galmore. We're just asking to be reset on another announcement. Okay,
Okay, it looks like Mr. Galmore just was hired in late June.
very recent. Yes, Your Honor.
Okay, any issues, Mr. Smith? Mr. Powell, I'm going to reset your case one more time. That'll give you plenty of time to go over everything with Mr. Galmore, Ms. Simmons, so that at that next court date, we'll see if we can get an announcement. All right, you can go back with the bailiff. Good morning. Are you JV on Blunt? And this is cause number 26 DCCR 1220. Mr. Blunt is charged with murder in that case. Mr. Wilkerson has filed a motion asking that I reduce the bond, which is currently set at $1.5 million. And Mr. Wilkerson, you may proceed.
Yes, Your Honor. This case, Mr. Blunt has been incarcerated now since March. And with regard to his case, we are still missing evidence in terms of whether or not well, let me put it this way, the person named in the indictment is apparently an alias of the actual victim. And so the concern at this point is in part a primary concern is whether or not the state could sustain a conviction as the indictment is presently worded. That being said, Judge, a $1.5 million bond does not meaningfully give Mr. Blunt the opportunity to secure bail in this case. And so, in being reasonable with the bond reduction request, given the standard bonds for offenses of this nature, we believe a bond of $750,000 would adequately secure the defendant's appearance in court.
I need some, Mr. Blunt, raise your right hand, please, the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right.
Mr. Blunt, state your name for the record, please.
JV Blunt.
You presently working?
No,
Oh, well, obviously you are presently incarcerated in Jefferson County Jail, correct? Are you able to raise funds either by borrowing or disposing of assets to make bond in the present amount of $1.5 million? Do you believe that with the help of family and potentially friends, if the court were to reduce bail in this case, that possibility might be enhanced?
yes, sir.
Can you describe to the court your familiarity with the area? That is, do you have family here in Jefferson County?
Yes, sir.
Are you from this area?
Yes, sir.
And have you been in Jefferson County for the last 5 years?
Yes, sir. I'm in my life.
All your life? Ever moved away?
Speak up, please.
No, sir.
Prior to becoming incarcerated, were you working?
Not right before, I had just not working in the Ford Arena,
Okay. How long had you been there?
a few months.
Are you asking this court in the interest of justice to reduce your bond from the $1.5 million that is presently set at?
Yes, sir.
Pass the witness, Sherman.
No questions or service.
All right, any other witnesses?
No, Your Honor.
Mr. Smith, any witnesses?
No, Judge.
What is the state's position?
State is opposed to a bond reduction, Judge. It's not uncommon that bonds in murder cases are set at $1 million.
I need you to speak up too.
it's not uncommon in this court and in Jefferson County that cases for murder with facts such as these are set at $1 million or greater.
So
Like that's a sufficient bond in this case.
do you want me to take judicial notice of anything?
The affidavit of probable cause would be.
Okay, I'll take judicial notice of the court's file, including the affidavit of probable cause. Give me just a second to get that. All right, anything else?
Nothing from the defense, Your Honor.
Also, the jail records show he has disrespect for the staff and other inmates in jail while he's been.
I'll take judicial notice of, I just received a jail incident report. Has two incident reports on it from July 15th and July 9th.
And I would just note, Your Honor, that both of them involve minor infractions. It looks like being out of bunk after lights out.
Right, this time I'm going to grant the motion to reduce the bond. I'm going to reduce the bond to $1 million. There will be bond conditions of house arrest, as well as wearing a GPS monitoring device if that bond is made. All right, we can go back with the bailiff. Good morning. Are you Gabriel Cruz III?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in cause number 26 DCCR 0373, you're charged with a third-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you actually did what they charged you with?
yes.
And then in cause number 26 DCCR 0374, you're charged with the third-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060. And you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Cruz is not competent?
No, Your Honor.
And Mr. Cruz, do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State, sorry, we already did that. All right, I'm going to find, Mr. Cruz, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for sentencing so that we can get a pre-sentence report that'll give me more information about you and your cases, and then we'll come back later for sentencing. All right, you can go back with the bailiff. Good morning. Are you Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court and entered pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 in a motion to revoke his probation. He's on probation for driving while intoxicated third or more. This was unagreed. I've received the updated pre-sentence report. If you both had an opportunity to review that report.
You have, Your Honor.
Judge.
Any additions or corrections to the report?
None more, Judge.
I'm just saying.
Mr. Parker?
Judge, I mean, my intention, excuse me, was that, and what Ms. Malfina and I talked about is that he had some serious health conditions. He ended up using drugs. I don't know how long he had been using drugs in the past. He and I had a heart-to-heart talk, explaining the situation he's in, and we talked about Safe P being a great option for him. Now, his mind has changed, and I like to let him address the court, but he said being in jail, he's been in there for a while now. He said his mind's clear, and he was here before on oxygen, and he's able to breathe better with his emphysema and all the other issues that he's had. But he's indicated he just wants to take his time. And I mean, my position is that, I personally think safety is probably the best thing for him. But at the same time, if he doesn't want it and then why take him to bed? Somebody else could use it. I'd like to let him address the court, Judge.
So, Mr. Hebert, the recommendation was for potentially Safe P and to get you that help. Are you saying you don't want that?
I'd like to just go back to probation and give help to my own.
Well, that's not going to
That's
happen.
okay.
Yeah, so it's either Safe P or prison.
Safety. Yes, ma'am.
So here's the thing about Safe P. It's an expensive program. And I don't want you to, kind of like what Mr. Parker said, go just take up a bed and we pay $70,000, $80,000 for you to go and you don't get what you need out of it. If you don't go in with the right mindset, then it's going to be a waste of everyone's time. If you want that help, I'm willing to give it to you.
Yes, ma'am. Please.
Ms. Malfino?
And if I may respond to one other thing, I think part of his attitude was when he did the PSI is that he was like, I'm on drugs. And I think maybe now that he's been there, he's cleaned up a little bit and not on drugs and realized that the help, he really needs that. And
I mean, you
That's why
tested
it's-
positive 1 month after having an
Mhm.
angioplasty and a stent. You started using drugs again. So obviously you need some help
Yes, ma'am.
if you're doing that 1 month after that kind of scare. So,
Yes, ma'am.
Ms. Malfino, anything to add?
No.
So, Mr. Hebert, I'm going to give you this opportunity and I hope you take advantage of it. I'm going to find that you entered your pleas of true, freely and voluntarily, find all of those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. Let's see, you were put on in September 25. I'm going to order that, as a condition of your probation, you enter and successfully complete the safety program. If there are still ongoing medical needs, then they'll put you in the special needs safety to make sure that any of that's taken care of as well. So I'll let them determine which one, but it probably would be the special needs if you're still having some ongoing health issues. This is your opportunity to get clean, live the rest of your life, finish your probation, and not go to prison.
I appreciate it. Thank
You're
you.
not going to get an opportunity like this again, so take advantage of it.
Yes, ma'am.
So this was not an agreement. So I'm going to hand you the trial court certification. You have some rights to appeal. Can't imagine that you would since I just did what you asked me to do, but here is, if y'all will sign the bottom and then just give him the bottom. Good morning. Are you Brent Smith?
Yes.
And this is cause number 26 DCCR 0128. Mr. Smith was previously in court, entered a plea of guilty to burglary of a habitation. It was an agreement. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, ma'am.
Any additions or corrections?
None more, Judge.
Not from the state.
The court ultimately concludes that the probation violations have been proven and formally revokes the defendant's probation. Although the judge notes that the plea agreement includes a sentencing cap, she also emphasizes that the defendant has already received several opportunities through probation and treatment programs. The court follows the agreement and imposes a 5-year prison sentence, explaining that repeated violations and unsuccessful rehabilitation efforts can no longer be overlooked. The hearing serves as a reminder that probation is intended to provide a
My concern here is the drug issue and the type of drug specifically with PCP, and I'm not real sure that. I'm just considering potentially ISF for some treatment.
That was part of the recommendation.
I don't see that. I thought it was, I don't,
If
ISF, substance abuse.
it was part of the,
okay, well, it's not on here, but that's what made sense to me, so,
Yes, ma'am, that was part of the deal. That was
Okay.
the only reason probation was
Yeah.
offered in this case.
okay. Got it. All right, so Mr. Smith, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings, place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the ISF Substance Abuse Track Program. And then once you're released from that, you'll be on the specialized mental health caseload and be required to follow all of the rules, all of the recommended treatment, including medication. Whether you feel like it's something you need or want, if they recommend it, it's going to be part of your probation that you have to follow all of those rules and recommendations. Do you understand? It looks like any other follow-up treatment from after ISF. And obviously you are to remain away from 4325 Galveston Street. You cannot be anywhere near that location. Do you understand? All right, I'm going to hand you the trial court certification. It shows this was an agreement that I followed and you waived your right to appeal. You're very lucky, sir. Because the house that you broke into, most houses that you break into nowadays, you could end up with someone taking care of that on their own, especially if you enter into a law enforcement officer's house and traumatize them and their family. So you understand the seriousness of this. So if you do everything you're supposed to on this probation, this is a great opportunity. You don't have the conviction on your record. We're going to get you the help you need. You can be successful. But the other side of that is if you violate any condition of probation at all, you will be back here in court. You could be found guilty of the offense and sent to prison anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? All right, and go back with the bailiff. Good morning, sir. Are you Eric James Hebert?
Yes, ma'am.
And Mr. Hebert is here in cause numbers 2137340, which is a motion to revoke probation on a driving while intoxicated third or more. And then we've got 2137341 on a motion to revoke for deadly conduct, discharging a firearm. And what is the announcement?
Yep. Your Honor, I yield to the state. We discussed the case.
Judge, the last time we were here on June 9th, the court asked us to expedite that new arrest, DWI third. We did. We got with Niederland. They submitted the case, got with Ms. Hannon at the lab. She actually completed the lab and sent it to us last week, July 16th. So we'll be, I can try to see if I can get it indicted in the morning. If not, it'll be next
Next week.
Wednesday. We can take care of all three of those together whenever the court's ready.
So let's do this. I'll just do a normal reset. That'll give you time, once it is indicted, to get the discovery and everything you need on that one. You'll have a couple of weeks to get with Mr. Hebert, and if anything gets worked out, we can take care of it at the next court date.
That's fine. Your Honor.
Perfect. Thank y'all very much.
Thank you.
Thank you. You can go back with the bailiff, sir. Good morning. Are you Hillary Davis? And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Davis, in cause number 23, DCCR 1551, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for credit debit card abuse, state jail felony, and that was a 5-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of possession of a controlled substance, penalty group 1-1B, April 29th of 2026. And is that true or not true?
True.
Count 2 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically that you were at a place where a criminal act was being committed and you were accompanied by a co-defendant named Jonathan Rideau. Is that true or not true?
True.
Count 3 alleges that you failed to work faithfully at suitable employment and provide verification of that to probation. Is that true or not true? Sorry. Count 4 alleges that you possessed a drug, cocaine, April 29th of 2026. And is that true or not true? Count 5 alleges that you admitted to your probation officer that you used illegal drugs, marijuana and cocaine, April 21st of 2026. And is that true or not true? Count 6 alleges that you failed to never become intoxicated or under the influence of an intoxicating substance, and that you tested positive on April 10th of 2026 for cocaine and marijuana. And is that true or not true? Count 7 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? True, you said, I'm sorry? True. Count 8 alleges that you were at a location other than your residence at approximately 1:56 a.m., April 29th of 2026. Is that true or not true? Count 9 alleges that you are behind in your payment of restitution as of May 19th, 2026 in the amount of $297.50. Is that true or not true? True. And then count 10 alleges that you failed to pay court assessed fees as directed, and as of May 19th of 2026, you're $2,128 in behind. Is that true or not true? Did you enter your pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? Yes, ma'am. And do you understand if I follow the agreement that you've made with the district attorney's office that you'll be waiving or giving up any right to appeal? Yes, ma'am. And it looks like that agreement is for a cap of 18 months in the state jail prison, which means we'll come back. I'll get an updated report from probation, have a hearing on sentencing at a later date. As long as I give you 18 months or less, then you're waiving that right to appeal. Is that what you want to do? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Davis is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered the pleas of true to counts 2, 3, and then 5 through 10 freely and voluntarily. Find this counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing. Ask the probation department to do an updated report. Anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you're welcome. You can go back with the bailiff. All right, this is cause numbers 26 DCCR 0322 and 0323. And you're Nasir Brown. Are you going to answer out loud or no?
Sorry, I'm just going through some things right now.
Okay, so I just need to make sure, obviously I recognize you from being here before. I'm also going to take judicial notice of the court's file, and including a letter that you wrote to the court. In that letter, it does state from you that you were REL or REI, I can't read it, but anyway, Nasir Lewis Brown. So you're telling me that at one point in this letter you were Nasir Brown, and so Mr.
No relationship.
Mr. Rojas, what is the announcement?
Judge, Mr. Brown has told me on 2 different occasions now that he does not want a court-appointed attorney. He wants to represent himself. And I think he wants to address the court about that this morning.
I go by Mujahid Bey. That's the
fine.
name. That's actually who I go by.
That's fine.
Nasir Brown is a thing of the past.
Well, and here's the thing, unless you've changed your name, and I'm going to respect that that's what you want to be called and that's what you have.
That's what they want.
And that's who you are, but that if you have not changed your name legally, then I have to go by that legal documentation in the state of Texas, which is driver's license, identification cards, and what you were previously known as. So let's just get past what I'm calling you and let's deal with what the cases are and what we need to do about those, okay? So for purposes of what you want to do in the future, what Mr. Rojas is saying, that you want to represent yourself, I want to admonish you to a few things and then ask you some questions about that also. The first thing I'm going to tell you is that representing yourself is a terrible, terrible idea, because you will be required in any proceeding to know all of the rules and everything, just like the lawyers. You have to follow the rules of evidence, the rules of Texas evidence, the rules of Texas criminal procedure. Whether you think they apply to you or not, they're going to apply in this court. So what happens is, if you get in front of me, it's one thing. We can have this little bit of patience and I'm going to go, but you get a jury in there. And if you want a jury trial and you want to present a case to a jury and you're not doing it right, it's just going to get worse for you. I'm going to have to shut you down. I'm going to have to not let you enter certain documents in if you don't know how to do it properly. You're not going to be able to question certain witnesses if you're not doing it properly. So it's really, really a terrible idea to represent yourself. If you insist on that, I can go through some questions, but I'm assuming, am I correct that you don't have any formal legal training? Have you ever been to a school or any kind of legal training? Okay, so then am I right to say that you don't know what the Texas, those rules are and how to pick a jury or enter in evidence certain items at a trial and things like that, correct?
Yeah,
You do know how to do that?
to a degree, yes, I do.
So you would know how to properly, under Texas law, pick a jury and go to trial. I'm gonna tell you this, I didn't even know how to do it when I graduated law school. There's no way you know how to do that. And I'm telling you this for your own good. It takes practice and it takes sitting with people and learning and going to school to be able to really represent someone. I, as an attorney, and I bet these attorneys will tell you the same, if they were in trouble, wouldn't represent themselves. One of the first things we're taught in school, I was taught, don't ever think if you represent yourself, you have a fool for a client. That's what our professors told us. Because you're not able to represent yourself even as an attorney. You should get another attorney. So I really, really strongly recommend that you let Mr. Rojas help you. Mr. Rojas is a great attorney. He understands this process. He has a good relationship with the district attorney's office. He will either get you the best deal, or if you want to go to trial, we'll get you an attorney, Mr. Rojas or someone else that can take your case to trial. So if you want to go to trial, the first thing you have to do is reject a plea offer. So if Mr. Smith has made an offer, then you need to sign something that says, I don't want that. I want to go to trial. Mr. Rojas can get that this morning. It's not committing you to anything other than saying, I don't want to take that deal. I want to go to trial. I need that in my file so that I know why we're in trial. Does that make sense? So I need you to sign that rejection, and then we'll get your case set for trial. And we can talk about representation, whether or not it'll be Mr. Rojas or whether it'll be someone else who can get ready for trial as well. Okay. So y'all go sign that, and then I'll go over everything with you in just a minute. All right, sir. Are you Byron Jamal Morris? And Mr. Morris was previously in court, entered pleas of true to counts 2, 3, and 5 in a motion to adjudicate on probation for the second-degree felony offense of burglary of a habitation. I've received an updated pre-sentence report. Have you both received and reviewed that report?
We have, Your Honor.
Yes, sir.
Are there any additions or corrections to the report?
No, Your Honor.
Not from the state.
All right, and so, Mr. Smith, you've got witness with regard to other allegations?
Yes, Judge, in relation to count number 1, it was
Actually, Judge, count number 4. I think we're going to change our plate because he did admit to the probation officer that he was intoxicated, but on a different date than the arrest. So I think we can change that to a true.
So let me go through it then. So, Mr. Morris, you pled not true to counts 1 and 4. Count one alleges you committed that new offense of public intoxication November 6th of 2025. And in that case, you still want to remain with your
That's still
not true. And then count four alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. And is that true or not true?
Yes, ma'am.
It's true?
Yes, ma'am.
Okay, so I will change your plea in count number 4 to true. And Mr. Smith, you have witness with regard to count 1.
Yes, Judge.
You may call your first witness.
State Falls Officer Jensen.
Yeah, if you'll just kind of slide around a little bit. We'll just do this informally. Thank you, sir.
Right.
Good morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
Would you state your name for the record and spell it for the court?
Officer Michael Jansen, first name Michael, Michael, last name Jansen, Jantzen.
And how are you employed?
I'm employed by the Beaumont Police Department.
And what is your occupation?
I'm a police officer.
How long have you been a police officer?
A year and around 3 months.
Are you a certified police officer in the state of Texas? What training have you received to become a certified peace officer?
I've been through the basic police officer.
Can I ask y'all both to speak up? Your back's kind of to the court reporter as well. Thank you.
And what do you do? You said you're a patrol officer?
Yes.
What is a duty job description for a patrol officer?
General patrol, respond to calls for service, any number of calls throughout a shift. Could be honestly anything.
Okay. Were you working in that capacity on November 6th of 2025?
Yes, sir.
And about 11:38 in the evening, did you receive a dispatch?
Yes, sir.
And what, if anything, did you do as a result of that dispatch?
Immediately began operating my department issued patrol car in that direction and arrived on scene.
Okay. What did you observe when you got there? And describe for the court what location we talking about.
Yes, sir. 4705 Magnolia. It's the Swift gas station. They're dispatched there in reference to a person who was asleep at a game machine inside that gas station. We arrived on scene, entered the gas station, and observed a person asleep at the game machine. Attempted to arouse him by verbal stimulus. I then reached onto his chest and provided a physical signals to his chest. He did not wake up. At that point, he woke up after a few more conversations between my partner and I, and he woke up, immediately smelled the smell of alcohol emitting from his broken person, observed bright glassy eyes, and as we stood him up, we walked him out, to the police car and observed the unsteady gait as well.
Okay. In your opinion, did he appear to be impaired or intoxicated?
Yes, sir.
And did you feel like that was from alcohol and or other substances?
Yes, sir.
Was he impaired to the point that he appeared to be a danger to himself and to others?
Being that location is in a very high crime area in the city of Beaumont, I absolutely believe so.
And do you see the person that you encountered on November 6th of 2025 at the Swift gas station here in the courtroom today?
Yes, sir.
Would you point to him and identify an article of clothing that he's wearing?
An orange jumpsuit.
Gonna let the record reflect. He has identified the defendant in this case.
The record will so reflect.
And did you place him under arrest for public intoxication on that day?
Yes, sir, I did.
That's what Mr.
Thank you, Mr. Rojas.
So he was in a high crime area and that makes him a danger to himself or others.
Yes, sir. Being that he was asleep in that gas station, responded to several calls there for violent crimes. He was unable to be aroused by myself and another officer. I believe that somebody could have stolen any number of items from him or assaulted him or been a victim of any other crime.
What was the original call for?
A person asleep at a game machine.
Nobody said anything about anybody being violent or any fighting or anything like that, right?
Not at that time.
Okay. Was there ever at all during this call?
Not during that call, no, sir.
Okay. And when you were finally able to wake him up, he wasn't argumentative or disruptive with you, was he?
He woke up as a person would, surprised that there was two police officers. I feel like that's a normal reaction. That, all of a sudden there's two police officers with their presence right there. But I was able to take him in handcuffs immediately based off of that reaction, which felt for him.
And you said you did the chest, what's it called? The chest rub?
Like a sternum rub.
The sternum rub. Most people wake up immediately from that, don't they?
Yes,
Even intoxicated people.
general, in my experience.
In your experience, do you know of any kind of what would cause it? But you said he did not immediately wake up from that. What in your experience would cause somebody to not wake up immediately from that? If you know.
Any number of intoxicants in their system.
Okay. Could it also be due to seizures, maybe?
I'm not.
You don't know about that? Okay. You'll agree with if anybody in a high crime area is in a little bit of danger, right?
Yes.
Okay. I'll pass the witness.
Anything
No further
else?
questions, Judge.
Any objection to Officer Jansen being excused?
There you are.
Thank you for being here, sir. Any other witnesses?
No, Judge.
Right, argument with regard to count one,
I can call Mr. Morris on it, Judge?
on count one?
Yes.
Sure, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Right, go ahead.
Byron, you heard the officer's testimony, right?
Yes, sir.
Okay, and you and I have talked about this before, about count one, right?
Yes, sir.
Tell the judge, were you intoxicated on that night?
No, sir.
Okay, why were you asleep on that night?
I think I had a seizure on the machine.
Okay, and you are prone to seizures, aren't you?
Yes, sir.
And in fact, I think that's in the updated PSI that you do have seizures and the probation department knows about that.
Yes, sir.
Okay. Now, the officer says he smelled some alcohol. Why would he be smelling alcohol on your breath?
The only thing I kind of remember was I might have had an open container in the car. But I really don't remember.
Okay, so you admit that you might have been drinking alcohol on that night,
Might have, yes, sir.
but you don't think you were intoxicated?
No, sir.
Okay. And, well, pass the witness, Judge.
All right, Mr. Smith?
So, Mr. Morris, you're saying that you had a seizure, and as a result of the seizure, you had passed out to the point that verbal stimulus and physical stimulus did not arouse you, correct?
Yes, sir.
Do you take medication for your seizures?
Yes, sir.
What do you take?
Pepper.
How often do you take it?
Grams,
How often do you take it?
twice a day.
Twice a day. Do you know how alcohol affects that?
Not really.
So you have no idea what alcohol does to that drug. It's an anti-seizure medication. Yet you consume your medication twice a day and use alcohol at the same time.
Well, I don't drink like that, y'all, sir.
You don't.
No.
Well, you drink often because you were pled true to count 4, and you just admitted that you were drinking on the day that you were arrested. Right?
Yes, sir.
No further questions.
All right, any other witnesses with regard to count one?
No, Your Honor.
Any others rebuttal or anything, Mr. Smith? At this time, based on the evidence that's been presented, Mr. Morris, I am going to find count one true. That you did commit the offense of public intoxication on November 6th of 2025. So with regard to sentencing, Mr. Rojas?
Judge, Mr. Morris has been on probation since 2016. I think his probation has actually expired since March. It appears that from March of 2016, he was doing well until that first motion to revoke was filed in October of 2020. Notable, I think, as you can see from the updated PSI, at that time, he had some support of both of his parents, who unfortunately passed away, I think the following year, 21, when Mr. Morris was, at that point, was sent over to safety relapse in March of 21. And then it looks like at that point, his parents passed away. He went from March 21 to December of 23 until the second motion to revoke was filed based on a new offense that was ultimately dismissed. And that motion was resolved by jail sanctions and continued on probation. And that brings us to this new motion, which is filed from, I think in February of this year with the new allegations. So He's been on probation for 10 years. Other than this new PI, he hasn't committed any law offenses. Even though one was alleged, that case was dismissed in 23. It's unfortunate, I think, that his parents passed away because it looks like they were the support for him. They were able to give him some guidance while he was on probation. He was doing well while they were alive. And even after they passed away, other than administrative violations and this new admitted drug use and alcohol use, which is serious. I understand those are violations of probation, but he seemed to be doing well until this new motion was filed. I don't know what we can do with him, Judge, because probation's expired. My recommendation, or I guess what we would ask the court to do is to let this time that he's been in jail serve as sanctions and let his probation expire.
Right, thank you. Mr. Smith?
Judge, I believe the recommendation probation officer is absolutely spot on. I think he's taken advantage of the court's leniency. We've sent him to Safe twice. He's been in drop. He's done the moral recognition therapy. He has not gotten any benefit from all the programs that have been offered and completed. He blames the fact that he can't act like an adult because he doesn't have people to tell him what to do, but he's an adult. He shouldn't have to have people tell him what to do. He's been given every opportunity, and just letting it expire would be not justice in this case. We believe that probation should be revoked and he should be sentenced to time in TDC, understanding that he will get credit for the time that he successfully completed Safe. So we would ask for a significant amount of time in prison.
Thank you, Mr. Smith. Mr. Block's here and you have your updated report. Is there anything else that you would like to add, sir?
No.
All right, thank you. Mr. Morris, Mr. Smith is absolutely correct. I'm looking back at that original PSI, and the original PSI wasn't even agreed. It was a cap of 8 years in prison. And on that day, I gave you the opportunity for this probation, and you have had multiple. This is your third motion to revoke. So it hasn't all gone well. And the fact that you've been given those opportunities at Safe twice and you're still doing what you're doing, I'm going to again I'm finding count 1 true, find that you entered your pleas of true to counts 2 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. You're lucky that the agreement in this is for a cap of 5 years. You know, the cap went down from the original, which is usually doesn't happen. I'm going to follow this agreement, but you're very lucky. I'm going to sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you. You can go back with the bailiff.
Thank you.
Excuse me, Johnny Segita, Mr. Rojas, it's a sentencing.
Johnny. Good
Good morning. Are you Avriana Dorsey?
Yes, ma'am.
And Ms. Dorsey was previously in court, entered a plea of guilty to burglary of a habitation, first degree felony. Have received the pre-sentence report. Have both of you had an opportunity to review that report?
I have, Judge. Yes, Your Honor, we have.
Any additions or corrections?
Nothing finished. Not from the state, Judge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation, including entering and successfully completing the cognitive track of the ISF program. I also noticed in here that there was $450 in restitution that was requested. Did you
Yes.
have any other information about that?
Judge, I think that was just damage to the door and everything, when she came in, and we are asking that be added as payment of restitution.
I'm going to order that $450 in restitution as well. Ms. Dorsey, this is a great opportunity for you because you don't have a felony conviction on your record. This is a very serious offense. And so if you do everything you're supposed to, when you complete the probation successfully, the case will be dismissed. You'll never be a convicted felon. The other side of that, though, is extremely serious because if you violate any condition of probation, you can be brought back into court, found guilty, and sent to prison for between a minimum of 5 years up to 99 years of the rest of your life. Do you understand? ISF is meant to help you make better thinking decisions and things like that. So please take advantage of that program. Listen, learn, so that when you get out, you'll be successful. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, ma'am.
Thank you, Your Honor.
Thank you. Good morning. Are you Mary Robinson? Can you say yes or no for me?
Yes.
Thank you. And Ms. Robinson, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Robinson, in cause number 24, DCCR 1116, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation December 2nd of 2024 for aggravated assault with a deadly weapon, a second-degree felony, and that was a 10-year deferred probation. Is that correct? Can you say yes or no for me?
Yes.
Thank you. It alleges that you violated your probation. Count 1 says that you committed the new offense of criminal trespass, May 7th of 2026 in Jefferson County. And is that true or not true?
That's true.
Okay. Count 2 alleges that you failed to provide verification of performing the community service hours required. And is that true or not true?
True.
Count 3 alleges that you didn't enter and successfully complete the forensic program at Spindletop. Is that true or not true?
That's true.
Count 4 alleges that you didn't enter and successfully complete the anger management program. Is that true or not true? Count 5 alleges that you did not enter and successfully complete a parenting course as ordered. Is that true or not true?
That's true.
And then count 6 says that you're behind in your court assessed fees. Is that true or not true?
That's true.
Okay. Did you enter your pleas of true to all of those counts freely and voluntarily?
True.
And did you plead true because they're all actually true?
Yeah.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. We'll get an updated pre-sentence report and then we'll come back. Anything that you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back.
Okay.
Okay, you can go back with the bailiff. Are you DeMarcus Elam?
Yes, ma'am.
And Mr. Elam is charged in cause number 26 DCCR 1221 with the first-degree felony offense of murder. And Mr. Reynolds was appointed to represent Mr. Elam. Ms. Holmes has stepped in while Mr. Reynolds is out for some time and has filed a motion asking that I reduce bond in Mr. Elam's case, which is currently set at 1.5 million. Is that correct?
Two.
Is it his is 2?
Yes.
Okay. And this is the co-defendant to the Mr. Blunt that I previously handled earlier today. All right, so let's just let me just ask the state with regard to what I did on the previous one. Is there any reason that this one should be treated any differently?
And judicial economy and all fairness, Judge, I think it would be appropriate to set both bonds at the same.
Okay, I will let you put some information on if you need or some evidence. I did grant the previous motion on Mr. Blunt's case and reduce the bond in that case to $1 million with the GPS and house arrest. I'm willing to do that based on the same information, unless you have something very different to point out about Mr. Elam other than just he can't make the big bond.
Right, that's it. And just as far as where he would be staying, his mother resides in Humble. And that's the home that he would like to go to.
What started as a routine day in court ended with life-changing decisions for multiple defendants. Some were given one final chance through probation and treatment, while others learned that repeated violations eventually lead to prison. Judge Raquel West made one message crystal clear: accountability matters, and every choice has consequences. Which decision surprised you the most? Let us know in the comments below. If you enjoy real courtroom breakdowns, don't forget to like this video, subscribe, and turn on notifications so you never miss the next dramatic case. Thanks for watching, and we'll see you in the next one.